This is Ellen Mitchell, your Heels on the Ground Realtor, and I'm here today for part one with probate attorney Stephen Schwartz. He is an elder law, probate, and guardianship attorney, and we have a lot to talk about. I hope you enjoy our interview. I'm Ellen Mitchell, certified probate real estate specialist and your Heels on the Ground Realtor. I'm here this afternoon with Stephen Schwartz, probate, guardianship, and elder law attorney. Thank you so much for taking the time to meet with me today.
Thanks for having me.
Absolutely. I sell a lot of probate properties, and so today we're going to talk about how to sell a home in probate, and we're going to get the real information from the expert. Is it okay if we get right into it?
Let's do it.
Okay. What are the common misconceptions that people have about selling a probate property?
So one of the most common misconceptions that people have is that you have to wait for the probate process to complete before you can sell the property, and that's not the case. Typically what we do is we get an order from the court approving the sale. Money is held until it's time to distribute it.
Can you tell us a little bit more about that and how it works?
Sure, it's very simple. One of the things that the court wants to know is whether the property is being sold at an arm's length sale. So typically what we'll do is we'll either have an appraisal done if one is available. Sometimes we'll have either like a pencil search done by the broker. The courts will typically accept that, or a formal appraisal. And then the court knows that the price is a fair price. And if the beneficiaries are willing to sign a waiver and consent, we can usually get that order very quickly without even a hearing.
That's great. How does someone know when to contact you? At what point in the process should someone reach out to you?
Well, as soon as you know you're going to be inheriting a property would be the right time. Since we're dealing with issues of death, nobody knows when someone's going to die. Sometimes you know death is imminent, and then you could contact the attorney or the realtor when you're anticipating that that's going to happen. Or it will frequently happen that somebody dies and the issue of a sale doesn't come up. People maybe are living in the house and they're going to sell it later. So really each case is unique. There's no one size fits all.
That makes sense. Who signs the paperwork and makes the final decisions when they inherit a property? How do you know who is the correct person? How does the person know who's the correct person to execute the documents?
Well, that's a great question. So that really is going to ultimately be determined by the title search when that's done, because sometimes people think they own a property that they don't own. There could have been a title defect from years ago, which sometimes needs to be resolved in a separate proceeding. But ordinarily, the title report will indicate who are the people that own the property, what interests they own, and what documents are required to convey the property to the buyer.
So if multiple people inherit the property, is it one person that signs the documents, or do you need everybody to sign the documents? And who do they go to for direction? Is it you that they would go to for direction with that?
Well, typically it's going to be a combination of me as the probate lawyer and you as the realtor, because you're going to most likely be the first contact. They're going to want to sell the property, and then you'll find out that the reason that they're selling it is that the previous owner passed away, one of their relatives. So at that point, you might send them to me, and I'll get the probate estate opened, and when you want to sell the property, we'll get an order approving the sale. And it'll be the title company at that point that will say which signatures are required. Because even if the judge says this is the person that owns it, if the title report comes back and says it's somebody else, the buyer's not going to complete the sale without knowing that they're getting good title. So even though you have the courts, which is supposed to be the law, it's really the title insurance company that's going to dictate which signatures are required.
So it really is a team effort between the attorney, the realtor, the heirs, everybody working together. Exactly.
There are a lot of moving parts, but if the people are experienced in what they're doing, we can make it happen usually pretty quickly. Not that much additional time is going to be required when there's a probate sale. And it's happened frequently that I get the order approving the sale even before the title report comes in.
Great. Top 3 tips for people that inherit property.
Well, number one, you want to preserve the property. So if you inherit it and you don't occupy the property, you're going to want to get somebody who can go in and make sure that there's no water leaks, locks are in good shape, and I know that it's your custom and practice that you take care of that. That's probably the first and most important thing. And then you want to get your property, your probate process started as soon as you can, because if you're not living in the property, you're going to lose your homestead exemption if you had one. You're going to be paying insurance, and you don't have anybody paying rent. So it's a good idea to get the property sold as soon as possible, unless you're going to live in it.
That's such a good point. I see so many times that the heirs are up north, the property is down here, and people really don't know where to turn when they inherit the property.
This week I have a brand new client, and he has exactly that set of facts. He's had the property for almost a year, and he's been paying the association fees and the taxes, and nobody's renting it. Had trouble with a previous attorney, and I'm going to help him get it done very quickly.
So it's important to know that you have a good team that you can, that you can count on. Homestead and non-homestead property in a probate sale. I know these are terms that we hear often in this world, but something that people may not be familiar with.
Sure.
So what is the difference between homestead and non-homestead and the rights that the heirs have in the property?
Okay, great question. So when property is homestead property, it means that's the property that the person that passed away lived in as their main residence, and it comes with certain protections under Florida law, such as, for example, if the person had a judgment against them, that property cannot be sold to satisfy the judgment. It's 100% protected, and there are some other protections as well. When someone dies, that property at that moment passes to the heirs at law, regardless of the will. So you might think that there's a will that gives the property. That's not always the case. It's going to depend on the ages and relationships of the heirs and the beneficiaries of the estate. If the property is homestead, you do have to get the order determining homestead in order to make sure that the proper people are going to be conveying the property. So the title company is most likely going to be involved in telling you which signatures are required, but that order determining homestead is not going to come until after the creditor period, which is a 90-day period after the first date of publication that gives creditors a chance to file a claim in the estate. And the reason that's important is that they might want to contest the homestead. If the property is not homestead, you sell it like any other piece of property, and then the proceeds of sale would typically go into a restricted bank account. Dade and Broward counties, other counties will use a bond instead. And then the property, the proceeds of the sale would stay there until it's time to distribute.
What kind of time frame are people looking at if they're inheriting a property, they're out of state, the property was or was not homesteaded, from the time that the death occurs till the time of the sale? Are we looking at months, a year? What kind of time frame are we looking at in that?
So as you know, when we're talking about real estate sales, market factors are in play, so supply and demand. So right now, in the early part of 2022, it's a seller's market. There's not enough supply. So typically, the contract is going to be in place almost immediately because everybody wants listings, everybody wants to have the property, and the property is going to move very, very quickly. And it may be the probate process is a little bit behind. But in other markets, it may be just the opposite, where nobody wants to buy the property, in which case it's not so much the probate process that's in the way, but market factors. Typically, the delay that may be involved in a probate proceeding is really not that much. It's typically maybe 30 to 60 days. Sometimes less, sometimes more, because as you know, every estate is different.
I hope you enjoyed part 1 of the interview with Stephen Schwartz. There's a lot more coming up. Please like and subscribe below. It helps our channel a ton, and please watch part 2.